Welcome. Thank you for being here for our latest Bowden Fellows lecture. I appreciate everyone coming out. Hope you're getting some good food and enjoying yourselves. As you know, we've had a different variety of folks exploring different topics in our Bowden Fellows series. Some are well-established academics and professors. Others are getting ready to go on the market or in the middle of being on the market. Today we have an attorney who is preparing himself to become a legal academic, which takes some time, actually. You actually have to do, these days you have to do what academics used to do after they got their jobs. These days you have to do that before you can even pretend to try to get a job as a professor. And so we're hosting someone who's well in and well on his way to doing that now. I'm going to introduce our speaker and then get out of the way, and it'll be the format that I think many of you are familiar with. He'll give his talk and presentation for about 15 to 20 minutes. And then you all should feel free to aggressively ask him questions. And to you students, I mean that. Aggressively ask him questions. If there's a question on your mind, don't think it's dumb, just ask it. I'm sure somebody else is thinking it as well. And I'm going to speak for Tyler now and say I'm sure he'd love to be challenged on things. So go for it, okay? Tyler Dobbs is an associate at the appellate litigation boutique Consovoy McCarthy. He graduated from Harvard College and received a master's degree in classics from Oxford. He then returned to Harvard for law school, where he served as an editor of the Harvard Law Review, worked for the Harvard Religious Freedom Clinic, and received the Dean's Scholar Prize for Best Performance in Federal Courts. Tyler graduated magna cum laude from HLS in 2022. After law school, he moved to Dallas to clerk for Judge James Ho on the Fifth Circuit. He then clerked for Judge Thomas Hardiman on the Third Circuit in Pennsylvania. Tyler now lives and works in the DC area. His first full-length law review article, a paper on the Erie Doctrine, is forthcoming in the Notre Dame Law Review. And today he'll be sharing us a different article that he's working on and preparing to submit to academic journals. So with that, please help me welcome Tyler Dobbs.
Yeah, thank you so much for that introduction. It's really great to be back here in the Lone Star State. As you just heard, I clerked on the Fifth Circuit in Texas right after law school. And it was during that clerkship that I first began thinking about the Supreme Court's emergency docket. So it's really appropriate that I'm giving this talk right here at Texas's flagship law school. So today, I'd like to explore with y'all a dilemma that the Supreme Court is facing. The emergency docket, and you might have heard it called shadow docket, is another common name for it. The emergency docket has put the Supreme Court between a rock and a hard place. When it's ruling on a short fuse emergency application, the Supreme Court faces a choice. It can either write an opinion explaining its ruling, or it can write nothing at all. If the court writes an opinion, then that opinion becomes binding precedent for every single court in this country, including the Supreme Court itself. And that's so even though the opinion might have been written hastily and with little reflection in an emergency posture. But if the court writes no opinion, then it faces criticism for issuing an unreasoned, unexplained order, though that order will have enormous consequences for the country as the litigation proceeds. As a solution to this dilemma, I suggest that the Supreme Court should adopt a familiar lower court procedure, the non-presidential opinion. This procedural device would allow the court to articulate its rationale in every case, but without locking that decision in. This discussion is going to have 3 steps. Step 1, I'll set up the dilemma. Step 2, I'll turn to history for a solution to the dilemma. And step 3, I'll flesh out what that solution looks like and maybe respond to some possible counterarguments. So let's start with the dilemma itself. For around the last decade, the Supreme Court has been facing a huge number of applications for emergency relief. Now, the emergency docket itself is not new, but for much of recent legal history, it was largely limited to death penalty cases, these emergency stays of an execution, for instance. But what we're talking about here are emergency applications that have to do with new laws, new policies that are challenged in court. So these emergency applications that the Supreme Court is getting in huge numbers, they're asking for one of 2 things. 1, a preliminary injunction, or 2, a stay. So a preliminary injunction puts a policy on hold at the outset of litigation. And a stay, which is the other option, a stay puts a lower court order often an order enjoining the policy's enforcement on hold while the litigation proceeds. So both are trying to put something on hold while we have, litigation winding its course through the courts. An injunction request and a stay request are both governed by a legal test that asks which side is likely to prevail on the merits of the ultimate litigation. So to rule on an emergency application, the court normally has to take an initial position on the merits of the case right at its start. And it can't kick the application without ruling on it. The court either has to grant the application or deny it. But the court doesn't always say why it ruled the way it did. In a lot of emergency docket decisions, it simply grants or denies the request for relief without any public statement at all. This has led to criticism coming both from the legal commentariat and from within the court that the court is issuing unreasoned and unexplained orders on questions of immense national significance. The most prominent academic critic is probably Professor Steve Vladeck, who's written extensively to criticize the court along these lines. And justices dissenting from emergency docket orders frequently lambast the majority for leaving its decision, quote, entirely unexplained, unquote. Even Judge Trevor McFadden, a known friend of the justices who are often in the majority, has said, and I'll quote, the most compelling objection to the emergency docket is that these orders typically come without an opinion from the court. Dissenting justices also made this complaint in the past. I agree with Professor Vladeck that this is a frustrating feature, Judge Trevor McFadden says, and unquote. So, and I'll say this, we're no longer quoting Judge McFadden, I think there's something to what Judge McFadden is saying. In the American legal system, judges have long been expected to provide at least some rationale for their decisions. This was a key insight of the legal process school of the mid-20th century, which many of the law students here might have studied. What makes judging, at least at the appellate level, different from other enterprises is that appellate judges give reasons for their decisions. And they certainly do so in important cases with high stakes. And this theoretical insight, it's not just a pie-in-the-sky theory. This is very consistent with American legal history. The systematic reporting of judicial decisions, that was new in the early American Republic. But the tradition of judges providing at least an oral explanation for their rulings, that's very old. Common law judges in the sort of Anglo-American legal tradition, they've provided explanation for their decisions since at least the 13th century. And practitioners from the get-go have been present to record those reasons. So it's somewhat unusual that the court has not been explaining many of its emergency docket rulings at all. When confronted with this criticism, some justices have provided a persuasive response. Namely, they say, we want to be careful about writing on the emergency docket because there will be a lock-in effect with any opinion that the court issues. Justice Kavanaugh flagged this problem in his important concurrence in an emergency docket case called Labrador v. Poe. And there he wrote, and I'll quote, an opinion for the court addressing the likelihood of success on the merits for an emergency application can sometimes come at a cost. A written opinion can create a lock-in effect, unquote. And Justice Barrett has frequently reiterated this same point in the interviews she's been giving for her recently released book, Listening to the Law. So this concern that these justices have articulated, I think it's warranted because of vertical stare decisis. That's the principle that lower courts are bound to follow the precedent of a higher court. Once the Supreme Court issues an opinion, every single court in the country is bound to follow its precedent, at least in procedurally analogous cases. And it's been clear for several years, around half a decade, that emergency docket opinions are indeed precedent. And by the way, this is where the First Amendment, where the First Amendment is centered. This is where the First Amendment comes into this paper. So in the fall of 2020, the Supreme Court issued a path-breaking emergency opinion in Diocese of Brooklyn v. Cuomo, which held that the government violated the First Amendment when it closed churches and synagogues but left comparable secular businesses open. This emergency docket decision was soon cited as controlling precedent by the Supreme Court itself and by the U.S. Courts of Appeals. And just this summer, a few months ago, the Supreme Court reiterated in a case called Boyle that emergency docket opinions must, quote, inform how lower courts rule in like cases, unquote. Because the Supreme Court expects lower courts to follow its emergency docket opinions as controlling precedent, it may be hesitant to issue those opinions at all. After all, these emergency applications come at the very start of litigation. So issuing an opinion risks stopping percolation in the lower courts just as the conversation is beginning. Moreover, the severely truncated procedures of the emergency docket. There's no full briefing, there's no oral argument, there's no conference, and there's little, if any, time to exchange draft opinions. That all means that the emergency docket is poorly suited, in many cases, for setting precedent. So although there are very good reasons for the court to explain its emergency docket decisions, there are equally, I would say, weighty reasons for it to hesitate before setting precedent on the emergency docket. So now we've set up the problem, and we'll turn to history for a possible solution. This isn't the first time the federal judiciary has been flooded with requests for relief and wary about setting precedent when ruling on them. The federal courts of appeals, so the intermediate appellate courts in the federal system, they hear appeals, and then people can appeal up from there to the Supreme Court. The courts of appeals faced much the same problem in the middle of the 20th century. That period, the middle of the 20th century, is when two things happened simultaneously. One, court dockets were swelling faster than Congress could add new judicial circuit seats. And two, circuit panel opinions were recognized as strictly binding for the very first time in American legal history. In response, the circuits created a new procedural device, the non-precedential opinion. This let a circuit explain its decision, but without setting precedent that bound the circuit. So for a little bit of context, let's walk through the circumstances that led to this procedural revolution. First, there were what judges and commentators called the litigation explosion. It's all over. If you read law reviews from this time, legal commentary, even Chief Justice Berger, they were all talking about the litigation explosion. So during this period, the Supreme Court was busy making new forms of relief available to litigants. It was reading old provisions with novel breadth. It was creating new judicial remedies for the violation of federal rights, and it was loosening justiciability doctrines, swinging the courthouse doors wide open. At the same time as this the courts are expanding availability to litigation, Congress is passing path-breaking laws like the 1964 Civil Rights Act and the 1969 National Environmental Protection Act, NEPA. These new laws, combined with plaintiff-friendly justiciability doctrines, meant that lower court litigation on big issues of public policy, there was more of it than ever before. And like the justices today, who have to rule on every emergency application that comes their way, the circuit judges had to rule on every appeal. Litigants then as now had an appeal as of right. If you don't like how the trial court comes out, appeal it up. You have a right to do that, and they have to rule on it. So even as they faced mounting caseloads with less time to decide each individual case, each individual case was more important than ever. So again, they don't have very much time to decide each case, but each case is enormously consequential. And that's because a single panel opinion, one opinion by one panel, one three-judge panel, now had the power to bind every single court within the circuit, including future circuit panels, forever into the future. That wasn't the historical rule. If you read William Blackstone, if you read Justice Joseph Story, you'll see that they viewed a judicial opinion as evidence of the law rather than the law itself. And so from the inception of the federal courts of appeals up until the mid-20th century, the courts of appeals treated a past panel opinion as persuasive rather than strictly binding on future panels. You would definitely strongly consider it, but if the later panel disagreed and thought the panel had gotten it wrong, they could say we're going to go in a different direction. That all changed after the invention of en banc review in the 1940s. Once the circuits had the power to sit en banc, and that means not just in a three-judge panel, but you have all the judges of the circuit. It could be 16 judges rehearing the case. After en banc review was invented in the 1940s, every circuit determined that only the en banc court, only the full court, all the judges, had the power to revisit the precedent of a panel. And because en banc review was relatively rare, even say in our own, where we're at Fifth Circuit, which here's, compared to other circuits, a lot of en banc cases, it's still relatively rare. That meant that the first panel opinion on an issue was, for all practical purposes, the circuit's final word. Just as any Supreme Court opinion now sets law for the whole nation, any panel opinion, three-judge panel, would set the law for the whole circuit. In these circumstances, the circuit courts of appeals invented a new procedure, the non-presidential opinion. This allowed a circuit to explain its decision in a case, but without creating binding precedent. As a federal judicial advisory body explained in 1973, and I'll just quote this, one of the major objectives is to institute a procedure by which judges can write opinions for the benefit of the parties without having to include all the factual background and all the detailed rationale that's required for opinions that will enter the body of precedential law. And that report went on to explain, and again, I'll quote, an opinion prepared to inform the parties of the reasons for a decision may properly be quite different from an opinion that will be published and become part of the body of precedent. The court should be able to disclose its reasoning without the judge having to acquit his legal scholarship in every single opinion, unquote. So today, like most circuit opinions are actually non-precedential, and circuits will often use non-precedential opinions to decide significant cases that have important national political implications. Indeed, circuits are especially likely to use unpublished opinions to decide their own emergency docket cases. Like the Supreme Court, every circuit, there are 12 circuits, I guess 13 really, but every circuit has its own docket for emergency motions. Non-presidential opinions let these lower courts explain their short fuse rulings on emergency motions, but without irrevocably setting circuit precedent. So given that the lower courts are using the unpublished non-presidential opinions this way, that could help resolve the Supreme Court's emergency docket dilemma. So we're going to now turn, this is step 3, we'll turn to my proposed solution. Like the federal courts of appeals, the Supreme Court should adopt a distinction between precedential and non-precedential opinions. This would let the court explain emergency docket decisions while keeping the conversation going. When the court is deciding a novel issue on a short fuse, that's what often or even usually happens on the emergency docket, the court should briefly explain its decision in a non-precedential opinion. In other words, a short non-precedential opinion, that's my alternative in those cases where the court's currently declining to write at all. But I'm not suggesting that all emergency docket cases need to be designated as non-precedential. When the court is confronting an issue that's seen repeatedly before and on which it's sort of arrived at a developed view, the court shouldn't hesitate to designate the opinion as precedential, even if the case happens to come up in an emergency posture. And to flesh this out a bit, non-precedential opinions would be for emergency applications where the court is flying by the seat of its pants. You have a new federal regulation, a new executive order, a new state statute, and the justices, they haven't ever seen anything quite like it before. They have to decide quickly and without much briefing or reflection whether there's an irreparable injury, which side the equities favor, and most of all, whether the policy is ultimately likely to withstand legal challenge on the merits. In these circumstances, the justices don't have much to go on but their initial legal intuitions and some preliminary research. And they may want the issue to keep percolating in the lower courts below so that they can get the best arguments for each side and ultimately figure out what the law is. These are precisely the circumstances that, on my proposal, call for a non-precedential opinion. By contrast, some issues come to the court repeatedly on the emergency docket. 2 examples are, I mentioned earlier, COVID restrictions on houses of worship and the presidential removal of high-ranking executive officials. Both issues came up so frequently on the court's emergency docket that the justices, after seeing multiple emergency applications, were able to figure out what they thought about the legal issues. In the COVID cases, they settled on a First Amendment rule. Churches have to be treated just as favorably as comparable secular entities. And in the removal cases, they've settled on an Article 2 rule. Heads of multi-member agencies are removable at will by the president. Once the justices have found their principle through a deliberative process occasioned by repeated decision-making on the same issue, they should feel free to elaborate that principle in precedent that will control, at least in other cases that involve preliminary relief. This proposed distinction between precedential and non-precedential opinions, I argue, would benefit everyone. It would benefit the public by enabling the court to provide some explanation in every single case. A non-precedential opinion would indicate the court's desire for further percolation, so this proposal would also benefit litigants by directing their energies to areas where the court has signaled it has an open mind. The distinction would also benefit lower courts. By choosing to designate an emergency docket opinion as precedential, the court would signal that it had arrived at a considered legal view of the issue. This would provide unmistakable guidance that the justices expect lower courts to comply faithfully with the rule articulated, at least in any case involving preliminary relief. This would avoid confusion in or overly fine distinctions by lower courts. Finally, this proposal, I think, would benefit the court itself. Without significantly increasing the court's workload, I should say, it would spare the court of the accusation that it had failed to explain its decisions. It would also make the court's job easier by letting it signal where it could use help or where it had made up its mind. Unpublished opinions would promote helpful percolation by allowing the court to indicate where it was still figuring out its position. And published opinions would promote dutiful compliance with the court's decisions by letting the court indicate where it had come to a relatively stable view of an issue. Finally, I'd like to flag a few possible counterarguments and explain why I think each one falls short. One possible counterargument is the idea that non-presidential opinions are just unconstitutional. Some people have said this. It's an opinion that's out there. And this argument might have had some force before 2007, because before 2007, some federal courts prohibited parties from even citing non-presidential opinions. But ever since 2007, the federal rules of appellate procedure have allowed parties to cite non-presidential cases freely. They just don't constitute binding authority. And from a historical perspective, there's nothing unusual about cases that are merely persuasive rather than binding. As I suggested earlier, throughout most of English legal history and much of American legal history, judicial decisions in general were viewed as persuasive rather than binding. They were evidence of the law rather than the law itself. So there's nothing constitutionally suspect, I'd argue, about having some subset of decisions that are merely persuasive rather than controlling. Another counterargument I've heard is that lower courts will just continue to follow the non-presidential opinions as if they were precedent. But I think this can be avoided by the court writing relatively short non-presidential opinions that explain the outcome but don't provide a ton of analysis. And that's a practice that at least some circuits already employ to limit the usefulness of non-presidential opinions in subsequent cases. The idea is that you're just sort of writing to explain the decision in this controversy, not trying to set law for future cases and controversies. Moreover, emergency docket cases involve the most contentious and high-profile issues in the country. Those are issues where lower courts are most inclined to engage in motivated reasoning to avoid outcomes they find distasteful. So lower courts are unlikely to defer in these circumstances to an unfavorable decision when they know it very clearly does not control. And even if a lower court judge ultimately chooses to follow a non-presidential opinion that she disagrees with, she'll be more incentivized to explain her disagreement in a separate writing, which will also aid the development of the law as much as a majority opinion. One other counterargument is that this proposal is just a misuse of non-presidential opinions. Some people would say, they're meant for easy cases where the law is already settled. They're not meant to avoid making precedent in hard cases where the law is unsettled. But I think this characterization of non-presidential opinions is just untrue as a descriptive matter. As I suggested earlier, circuit panels frequently use unpublished decisions to decide hard questions when they want to avoid setting precedent. You run a quick Westlaw search, the database with all the cases, or you scan any circuit, their website, where you see the recent decisions, and you'll see that unpublished majority opinions frequently prompt concurrences and even impassioned dissents, especially in this Fifth Circuit. And as discussed above, circuits especially use non-presidential opinions to explain their rulings on emergency motions, including in the most high-profile of cases. In any event, regardless of how circuits may or may not use unpublished opinions, a non-presidential opinion is just a piece of institutional technology. Like other tools, you can use it for different purposes. The Sun King and Robespierre, they both employed the institutional technology of a centralized French state, but to quite different ends. So even if non-presidential opinions were only used one way at the circuit level, that wouldn't stop the Supreme Court from using this piece of institutional technology differently, at the Supreme Court level. Finally, I think you could argue that my proposal is insufficiently ambitious. If this problem happens when and because an emergency docket opinion locks in the law, why not just say, well, all emergency docket opinions are non-presidential as a categorical matter. They never bind. As late as last year, a Columbia Law Review article, in fact, argued, the article is called The Foreshadow Docket, that emergency docket opinions have zero value as precedent. But again, I just think this argument, despite, again, in a very illustrious law review by a very respected professor, I just don't think that's true as a descriptive matter, that these opinions are not precedent. However much, some scholars might want to argue, or might wish that emergency docket opinions didn't control as precedent. They just do, in fact, as a descriptive matter in the courts. The Supreme Court crossed that bridge half a decade ago in the Diocese of Brooklyn case we talked about. And its Boyle decision this summer eliminated any doubt that the Supreme Court expects these to control as precedent, these opinions on the emergency docket, at least again in procedurally analogous cases like a request for a preliminary injunction. Moreover, my understanding is that I think the justices, they just view the emergency docket like this, they view emergency docket precedent as too useful a tool for them to abandon it entirely. Sometimes the court has just arrived at a considered view, and an emergency docket application presents the best opportunity to articulate the rule it's come to. Without the ability to set precedent, at least sometimes on the emergency docket, the court would have no practical way to correct aberrant courts in developing doctrinal areas. The court would have to stay or reverse every erroneous lower court decision individually, or wait months or even years for the issue to return on its merits docket. So not all emergency docket decisions should qualify as precedent, but I'd argue the court should have the ability at least to sometimes set precedent on its emergency docket. As in the courts of appeals, the decision to designate the opinion as precedent or not should rest in the sound discretion of the court itself. And with that, I welcome your questions.
Okay, for those of you joining us for the first time, especially if you're faculty, we were not doing the normal queue procedure. Just raise your hands and Tyler will call on you. Tyler, make sure you scan the whole room. Don't ignore the left-hand side over here, which happens sometimes.
Sandra.
Oh yeah, folks, press the little button to use your microphone so you're picked up both in the room but also on the video. Okay, so make sure you press the button when you're talking.
In the front row.
Hi, thanks for coming. I had a question about your sort of your second criticism that you addressed, where you said that the lower courts often want to find ways out of following something they don't have to, right? And I'm curious if you've seen when the circuit courts issue a non-presidential opinion, the district courts below them are inclined to try to avoid the reasoning in a non-presidential opinion, or if they're inclined to follow it.
Yeah, so in the lower courts, non-precedential opinions are certainly not controlling precedent, but they are persuasive authority. So I don't want to overstate the degree to which, yeah, I mean, I'll concede. As a matter of course, district courts in this circuit or any other do tend to follow unpublished circuit opinions as highly persuasive. But I will say that's in kind of quotidian cases, like, an insurance dispute, or something about, some official immunity or something. That is to say, in these contexts where, lower courts decide a lot of these cases, they don't necessarily have strong priors about them. And so they're just happy to sort of follow what the bosses upstairs at the appeals court said, even if it's not precedent, even if they're not bound by it. I would just say that the types, and obviously all sorts of cases can come up on the emergency docket, so I don't want to paint with too broad a brush, but the types of cases that warrant emergency relief, usually that we're talking about here, again, we're kind of setting the death penalty context to the side. These are usually like a new federal policy, a new state policy, and I mean, they're just quite politically contentious. And as a descriptive matter, I do think that in those cases, judges and indeed, their law clerks have strong priors about what the law should be. And whether you like it or not, just as a descriptive matter, I would say as much as anybody, judges should follow the law as it is. But their priors may inform their view of what the law is and lead them to, again, I think they try to avoid in these emergency docket cases outcomes that they find distasteful or that strongly contradict their priors about how the Constitution, how democracy, how the rule of law works. Yes, in the back.
How do you see lower courts treating a non-precedential opinion from the Supreme Court any differently than they do Supreme Court dicta?
That's a really interesting question. I guess this is a bright line. So the bright line would be this is precedent, this is not precedent. The problem with dicta, and of course everybody would say it's like a trivial truism, and I'll repeat it, dicta is not binding, dicta is not precedent. At the same time, circuits do often say, and every circuit has a different law of precedent, so I'll try to hesitate to paint with too broad a brush, But lower, like circuit courts will say things like, you know, we take the dicta of the Supreme Court very seriously. We try to follow it wherever possible. And that's because I think in part, like the line between holding and dicta, it's fuzzy. And if you're a good lawyer, you can turn holding into dicta, you can turn dicta into holding. That's what, you know, many of the law students here in the room, you know, once you graduate, you're going to get paid the big bucks to do that. So, you know, this is a bright line though, right? This is, if it says like, you know, circuit opinions, they will literally say non-presidential or presidential, like literally at the top of the page. And you just see everything on that page. It's sort of like how if something's in a concurrence or a dissent at the Supreme Court, it's not precedent, you don't have to follow. You just know that. Unless it's like one of these splinter decisions where you only have a floor justice plurality. Absent that circumstance, if something's in a concurrence or a dissent, a lower court can feel free and should feel free and does feel free to ignore it. I mean, I think from experience, you only dig into the concurrences or dissents if they say something that you already think and that you just want to find some sort of support for and there's no binding precedent on it. As a general matter, I think lower courts wisely just ignore separate writings when they're trying to apply Supreme Court precedent. And my thought is that by having it say at the top, non-presidential, you know, lower court circuits, district courts, they would treat whatever's in that opinion the same way they would something that's in a concurrence or a dissent from the Supreme Court. Yeah, it's interesting because justice or justices here said it, but you know, it's not something that we have to follow. In the back there.
Yeah, I'm curious about like how public perception fits into your work. I heard about like in your analysis, like the benefits to litigants and to the courts themselves, but like I believe like a view of the public is somewhat critical to Supreme Courts and the emergency docket, both like the quantity of cases heard and just wondering how your proposal doesn't make like a bad problem worse for those people who just may see this as emboldening the Supreme Court to take on those cases and providing a sense of accountability that isn't the type of accountability some people in the public may want.
Yeah, I mean, I think, you know, several of the justices have said, you know, they don't do anything for the sake of criticism or whatever. And criticism is part of the job. When anybody who's a public official who takes an oath, you know, to follow the Constitution, they're going to have to make, and that's executive, that's legislative, that's judicial, that's all the branches. That's like even state officials, I think, take the same oath to support the Constitution. You know, everybody who takes that oath is ultimately going to be accountable in their consciences to whether they, you know, lived up to that obligation. So criticism comes with the job, I think. So I don't want to claim that any solution, mine or anybody else's, to the issue of the emergency docket, I don't want to claim that it's going to satisfy all critics. And but I just will note that, I mean, I try to follow the legal news pretty closely. I don't always succeed in that, but I do try to keep up with it insofar as the demands of, you know, job, family, whatever, permit me to. And the number one criticism I see in reporting on the emergency docket is this unexplained, unreasoned aspect. And as I hope I explained in the talk, I think there's really something to that criticism. Again, whether it's, you know, legal process theory, whether it's the history, whether it's something else, some other, you know, normative valence you're viewing this through, I think almost everybody can agree that as a normative matter, courts should explain their decisions. And I agree with that. So my proposal is trying to neutralize what I think is both the most common criticism of the emergency docket and the most compelling criticism of the emergency docket without, I don't want to claim that this is going to, you know, it's going to be, you know, everybody's happy with the emergency docket if the Supreme Court adopted my proposal. And you're right. I'm sure some people could come up with very trenchant criticisms even after the Supreme Court implements this proposal. But again, I'm focusing on one particularly compelling and particularly common critique of the court. Let me see, in the back row there. Thank you.
Isn't this just going to facilitate more use and potentially abuse of the emergency docket? And in doing so, somewhat bifurcate the system and just promote strategic lawsuits?
Sure. I mean, the Supreme Court can't exactly, because again, the way the procedure works is the Supreme Court has to rule on every emergency application. I don't think the ball is in the Supreme Court for whether an emergency application gets brought. It actually, I mean, I will say that these applications are very expensive to bring. when you file something in the Supreme Court, you have to print off like dozens of like actually hand printed copies with certain fonts and by a certain printer. It like costs like a lot of money to file any application for anything, cert or anything else at the Supreme Court. And so the decision actually kind of falls to the litigants to decide, do we want to, I mean, in particular, do we want to petition for cert? Do we want to, move or make an emergency application to the Supreme Court for relief? So, I mean, the decision lies kind of with the litigants, and in particular, a lot of these involve either the United States Solicitor General's office or perhaps state Solicitor General's offices. I mean, certainly the United States, like the United States government as a whole has like unlimited money. They can always just tax more. I guess assuming, I guess we're in a shutdown right now, assuming Congress wants to fund the federal government has unlimited money. And I mean, they can kind of bring emergency applications whenever they want. I mean, it's a strategic decision that they have to make. Like Solicitor General Sauer has to decide, and I think he's been particularly strategic in sort of making emergency applications where he thinks he can win. Same decision. I can't speak to all 50 of the state Solicitor General's offices or state Attorney General's offices in the country. I assume they're making similar kind of strategic decisions, and also perhaps because states don't have the same, they have more limited spending than the federal government. Maybe there are even cost concerns with, can we afford this litigation? And of course, sometimes individual parties do bring them, so they have to make both strategic and cost-saving decisions about. I guess I don't think it's the Supreme Court. I don't think the Supreme Court has the ability to say, oh, we're gonna, hear more of these. We're not going to hear more of these. They just have to kind of decide each one as it comes their way, and the decision, to make that emergency application is always within the hands of litigants. But if my question, I fear my question or my answer might not have been responsive to your question. So if you have a follow-up, I'd welcome it.
I guess over time, there's going to be more and more of these easier decisions that develop a law that's at a lower level, and it might be easier for litigants and cheaper and more affordable, whatever like that, to know that they can stop at that level. And even though it's not binding, you're right, even though it's not binding, we all know that these lower courts are going to somewhat treat it as presidential opinions. And so I could see how it could encourage more emergency appeals, because that's just the easier path.
Yeah, I mean, I don't want to discount the possibility that it could, but I do hope that even if there are more emergency, and I will say, yeah, even if there are more emergency applications, I don't know. And also there's sort of a hydraulics of it. If the Supreme Court hears more emergency applications, it has less time to consider and decide merits docket cases. So I don't know how the hydraulics of that play out. I do know my friends who have been clerking on the Supreme Court recently, they always talk about, oh, the merits part of the job is easy. The emergency application part is hard. This is taking up all my time, all my weekends. There are constraints of there's the staff in the building who are there to help the justices. The justices have other responsibilities too. I mean, they have families. They're doing different things. So I mean, there's I don't know how that plays out. Maybe it's a good thing if the Supreme Court has less control over its docket. Maybe it's a bad thing if the Supreme Court has less control over its docket on the merits side. But I will say that if the Supreme Court is deciding more emergency applications, as you suggest it might under this proposal, that will not be without, there will be hydraulic impacts on other aspects of the Supreme Court's docket. And maybe that's a good thing, because maybe the Supreme Court has less discretion over, oh, we're picking this case because we like it, and it just has to decide whatever cases come its way. I mean, until quite recently in the Supreme Court's history, actually, the Supreme Court had more of these mandatory appeals. Like the lower courts today, there was a lot of mandatory appeals coming to the Supreme Court. It was like only in the 80s that they got rid of the last vestiges. There's still a couple of very small pockets of mandatory jurisdiction, including, of course, the original jurisdiction of the Supreme Court, but also certain like election law type cases they have appeal as of right. But yeah, I would say that, I don't know, I think it could be a good thing if the Supreme Court has to decide more mandatory appeals, because then they are just like truly responding to litigant pressures and what parties are bringing to them, rather than picking the case that perfectly lets them do what they want to do. That's one suggestion, but that's just tentative. On the left here.
Your proposal seems sufficiently sensible to me.
We should press the mic.
Oh, sorry.
Yeah, your proposal seems very sensible to me, such that I'm wondering why the Supreme Court hasn't already adopted it. And I'm wondering what you speculate would be the biggest reasons that they haven't or would not adopt it in the future. Would it be, for example, concern about kind of separating categories of opinions and thus a loss of legitimacy because some of the opinions would be seen as lower status, and they'd be admitting weakness that, you know, some of their opinions are not to be taken as seriously as others. So welcome.
Yeah, so my thought about that, and that's an excellent question. I mean, I would love it if the Supreme Court adopted my proposal. I certainly don't expect it to. It's the Supreme Court. But actually, that is my answer. It's the Supreme Court, which is to say, I think it would be if the Supreme Court doesn't adopt this proposal, I actually think it would be due more to like vibes than anything. And I hate to use that word, but I think that's what it would be, which is to say we're the Supreme Court. We do things differently from the lower courts. Everything we say is like perfect. I mean, right? They're used to every opinion is just perfect. There's never a typo. They have a whole team of, they have like a whole team of people. Unlike the circuits, there's a team of people at the Supreme Court whose job is to make sure all the citations are perfectly in the Supreme Court's unique and idiosyncratic citation style. Like, and they pay them very good salaries, I'm sure, to just sit around taking the clerk's work and putting in, like, making the citations look right. So there's this just idea that everything the Supreme Court does is perfect. Everything the Supreme Court does is authoritative. Everything the Supreme Court does is final. Also, the Supreme Court just does things differently. Like in lower courts, in the courts of appeals, which like the Supreme Court decide cases in multi-member panels, in the courts of appeals, the judges are like emailing back and forth. They're calling each other. It's like kind of all like the most important is like whether to take a case en banc. You send an email, right? You're like literally people are on their phones sending I vote to take this case en banc or not. The Supreme Court does everything by paper. Like literally every single time there's a memo that goes out with edits to an opinion, a paper copy gets circulated to all 9 chambers, and like I'm sure it goes in the archives of the court itself as well. Likewise, the justices, my understanding is that by and large, outside of conference, which is a time when they just talk face to face with each other, they are not calling each other or texting each other. There's not like a group chat with the justices where they're arguing about how we could rule. They see themselves as a little bit above the fray, and most communication between chambers happens with law clerks as intermediaries. So there's just this sense that we're very formal, we're very, I don't know if stuffy is the right word, but like we do everything in this prim and proper way, we do it in the perfect way, and nothing we ever write or issue could ever be anything like secondary or lesser or, I mean, by designating an opinion as non-presidential, as I think I quoted that report from when this was kind of just this distinction between precedent and non-precedent opinions was emerging, like these are kind of like second class. We didn't have time to think about them. We didn't care that much. We were just like kind of cranking it out. And I could see the justices just in a vibe sense, because again, it's like everything's perfect, everything's prim and proper. They just wouldn't be into that. But that's kind of my best guess. I hope that answers your question. In the front row.
You mentioned that some people would view your proposal as unconstitutional. What would their specific argument be as to the constitutionality?
Yeah, there was this very, like, this is a pretty niche debate, so I'll try to explain it at a pretty high level of generality. In the early 2000s, an 8th Circuit decision held that unpublished opinions are unconstitutional. That prompted a huge debate in law review articles, what is going on? And you can't, like, people are really like worked up about this. And eventually that decision was vacated, so the 8th Circuit walked away from that position. But I guess, you know, I don't want to say there's nothing to it, right? Because there are some ideas of, oh, like we need public access to the courts. We need public access to justice. Everything the judiciary does should be on the record. And by the way, historically at least, like non-presidential opinions were unpublished opinions, which meant they didn't go in West's Federal Reporter. You had to go to the court and ask for an archived copy. Now with Westlaw and the internet, it's not really the case. But you know, I don't want to say there's nothing to the critique. I think just like a sense of like we need public access to the courts. We need people being able to know what the judges say. And then also, again, there were these no citation rules, which still exist in a modified format. Most circuits, I think, still have the rule that panels really are not supposed to cite non-presidential authority. Like you don't cite unpublished opinions. Instead, you just look at them and copy their reasoning and paste it into the published opinion and to say we thought of this ourselves. Or maybe you don't say that, but you don't say where you're getting it from. Which like kind of makes sense that but there was for a while a very strict no citation rule, which is to say like in the court rules that attorneys had to follow, and you might get like chided or forced to refile if you cited a non-presidential opinion. And I think there were some real, I mean, we're at the First Amendment Center. To me, that like has like free speech implications. If you're telling an attorney, oh, you can't even cite this in your briefs. I mean, I'm not going to say how the merits come out. This is a likelihood of success or something. I don't know, preliminary. But to me, that has very serious First Amendment problems if parties cannot cite in their briefs unpublished authority. So there's that, but they got rid of that in, I think, as I said, 2007, I think in response to this big debate about whether it was unconstitutional to have unpublished opinions or not. So, I mean, I think the argument's exceptionally weak because, again, the historic practice was literally like the Supreme Court for the first decade. There was you had like one guy who was like decently good, but he would just show up and take notes and then publish those and say, these are the US reports. So I don't think it's, and the colonies didn't have reporting of judicial decisions at all. The colonies relied exclusively on English reporters. Guys in Westminster were getting paid to sit around and jot down what the King's Bench or whatever, Exchequer were saying. And they would then publish those reports, and American courts would just sort of piggyback off of what the English courts were doing. And there in the colonies, there was nobody was getting paid to sit around in court all day and jot down what the judges were saying. So again, I think it's weak. I think, and then of course, the whole idea that a judicial opinion is controlling law rather than persuasive authority about the law is kind of a novel development. So in our American legal history, I think we've had a lot of things that are kind of like unpublished, non-presidential opinions. So I think the argument's weak, but I think it's motivated by very understandable rule of law concerns. Yeah, in the middle, back there.
Thanks for being here. So we've talked a lot about kind of the litigator's perspective and like what a non-presidential opinion could mean for them, but also I'm curious from your perspective if you've thought a lot about the judges themselves having written an opinion. I mean, even though they know it's not setting precedent, sort of our psyche as humans, and we know judges are humans, is to like kind of our pride is on the line, right? Like if we say something and we say this is our reasoning, even if it's like an initial reasoning, we kind of feel a little bit bound to like explain ourselves and stay true to that later on. So just curious if you had thought about that in terms of your framework.
Yeah, I mean, I guess I shouldn't speak too much about my confidential experiences in chambers, but I'll just, at a very high level of generality, I will say, I think judges tend to, and there are exceptions, so I don't want to paint with too broad a brush, but judges tend to pour themselves more into their published opinions. I mean, often these unpublished opinions are in fact issued per curiam. And as you might expect, judges certainly pay more attention or are more meticulous when their name is at the top of the opinion than if it's nobody's name. Per curiam, it could be any of the three judges on the panel. So I would just say, the unpublished opinions, I mean, everybody recognizes that they're not precedent. So I think there is a tendency, with these unpublished opinions that even the judges themselves writing them, you say they may have a sort of pride of craftsmanship, even in an unpublished opinion. I don't want to deny that straight. I think that certainly is true, that a judge can certainly pour him or herself into an unpublished opinion. There's a tendency, I think, for circuit judges to be much more concerned about something that one is going to be controlling authority for their circuit, which means they and all their colleagues have to follow it, at least if it's the holding. And you can draw a distinction between holding and dicta, but it's kind of a slippery distinction. And there is a tendency, if it's in a published opinion, it's the law for the circuit. So they're kind of very careful about that. Whereas with the unpublished opinions, I mean, I think I can say this in terms of not violating any confidences. Judge Hardiman on the Third Circuit had a saying that with an unpublished opinion, we write for the parties, and with a published opinion, we write for the world. And I just do think that there's a real difference psychologically on something that you're writing, like this is just for this case, just to sort of dispose of this appeal, versus something that is going to be controlling authority for you and your colleagues forever and ever and ever until it goes en banc or until the Supreme Court changes the law. Yes, on the left there, thanks.
Yeah, so when an appeals court issues a non-presidential decision, it can obviously be heard en banc or appealed to the Supreme Court, whereas you were just talking about like the finality of what the Supreme Court says. Do you not view that as like disrupting your analogy?
So, yeah, I mean, I guess I agree as a theoretical matter, you're absolutely right. As a practical matter, I draw a little distinction because the Supreme Court takes very few appeals. It used to be closer to 80. I think it's closer to 60 now, at least on cert. the number of cases the Supreme Court takes on cert, they're vanishingly small, and they usually involve like really like, I don't know, interesting sort of novel path-breaking issues. And by the way, there's a whole category of cases the Supreme Court does not take, which are state law cases, diversity cases, Erie cases. Those are all like the circuits say is the final say, at least in that case. Obviously the state Supreme Court could always like modify the state law and then the circuit would have to follow it. But at least as between these parties, and in this case, and until the state Supreme Court says differently, the circuit's word is the final word, and there's not going to be any appeal to the US Supreme Court because there's no obvious issue of federal law there. You're just applying state law. I guess there could be a meta Erie question like, are you applying the Supreme Court's Erie framework correctly? But they haven't taken one of those in years. So like as a practical matter, like literally the circuit's word on state law is the final word in this case between these parties, and there's no changing it. I guess, again, maybe the en banc court, but again, the en banc courts, if you look at what kind of cases en banc courts take, why would an en banc court take an issue of state law? You would certify it to the state Supreme Court. The en banc court is very concerned with the development of federal law, as makes sense for a federal court. So, I mean, and also again, like en banc decisions are very rare. Some circuits like truly never go en banc. Like the 10th Circuit like just doesn't go en banc. The 3rd Circuit hardly goes en banc, though, with some new appointments that might be changing. You just have these circuits that never go en banc. The 5th Circuit, they say it's like a huge en banc circuit. I don't know. I think it might be a dozen cases a year out of hundreds. And, a current 5th Circuit law clerk, Kelsey, a friend of mine, is in the front row. Maybe it's more than a dozen cases a year. I don't know what it's at now. But it's not like the 5th Circuit decides hundreds and hundreds and hundreds and thousands of appeals every single year from Texas, Louisiana, Mississippi. So as a practical matter, in most cases, the panel's word is the final word. So I don't see it as that dissimilar to the Supreme Court. And also, by the way, I will note in this preliminary posture, I think the Supreme Court's word on the emergency docket isn't the final word from the Supreme Court or any other court, because I do think that these even emergency docket precedents or whatever, certainly non-precedents, are about this PI context, preliminary injunction context. We're talking about what's the likelihood of success on the merits. If you have a court, whether a lower court or the Supreme Court, getting past that preliminary injunction stage and having a trial, getting to a summary judgment motion, a final decision on the merits, everybody agrees that those preliminary injunction decisions are like not controlling, and certainly not in the same way. So I hope that answers the question. Yeah, in the back.
Is there a trade-off that by issuing a non-presidential opinion, that it's, and to get in pursuit of like eventually getting the answer right and maybe fleshing it out more, I guess would that be a fair characterization, in that the actors in the system, not the attorneys, but the actual people like, Fed chairs, for example, or the people trying to fire them, are going to be more confused, and during the time when there's not a binding decision, it's going to leave them in like an absolute mess.
Well, that's an interesting point. I don't know if it will leave them in an absolute mess, because I mean, they know what the disposition of the preliminary injunction or stay is, right? Because now at least you explain it, what the court tentatively thinks. If anything, I'd like to argue, and I think I did argue this, if anything, it helps those parties, like the actual individual in the world, because that the Supreme Court is saying, oh, we kind of think it's this. We're not sure, but here's like what we think now. So it's actually the counter arguments that you want to attack. If the Supreme Court is saying, we tentatively think the law is this, but we're really, really, really not sure about it, as indicated by the fact that this is not a precedent. You want to go as, intensely as you can after those arguments and bring to bear all of the counter arguments and counter authorities. Though I guess maybe that's more the lawyer's perspective, but you can imagine that a lawyer having a meeting with the client, whether I think in your hypo, it's like an agency head or something, who's maybe fired or whatever. And you could have the lawyer say to the person who, may or may not be, I guess if it's a federal agency head, they're probably the following, but, to varying degrees with legal acumen, they might not be lawyers. Often these agency heads have successful fields and careers in other fields before going into government. You can imagine the lawyer sitting down with that client and saying, client, here's what the Supreme Court tentatively said. But you know what? The Supreme Court has indicated that they're not really sure about this. So I think we have a fighting chance. Here's what their arguments are, but here are the really strong counter arguments, and my associates figuring these out. But and we're going to flesh these out and we're going to win this. I don't know. I think that might actually help the real world parties whose names are who bring the complaints and whose names are in the caption. I think it could help them if their lawyers have more information, both about what certainly knowing what the Supreme Court's thinking now, even in a very tentative way, is better than not knowing what the justices are thinking without any explanation, which is what you often get in these cases. The lawyers have no idea. They're just sort of like, all they can do is say, well, the other side argued this in their response to the stay application, and like we can assume the justices were persuaded by those arguments, but you don't really know. Does that answer the question?
Yeah, definitely.
Okay,
I think we have time for one more. She's had her hand up for a long time.
please.
Yeah, a similar question to what we talked about before with why isn't the court doing this already? And maybe the answer is the same. But in terms of, you talked earlier about
these non-presidential opinions would have about the same weight as a concurrence or
Dissent.
a regular opinion.
Okay, there we go. So why do you think we don't see more of that, the concurrences speaking on these emergency dockets? Because we have seen that can happen. We've seen emergency docket cases with just a concurrence and no opinion. So why do you think the court doesn't do that right now?
Doesn't, just to clarify, doesn't do concurrences or doesn't do?
Doesn't just give concurrences on these opinions rather.
Actually, I guess I would say a lot of the emergency docket opinions do generate concurrences and dissents. And the reason why I think you see quite a lot of concurring and dissenting opinions, and it's because the individual author can write in his or her own voice, right? The justice, they don't have to run it by 5 or 6 or however many colleagues. They just say in their own voice what they think. So I would say, like right now, at least, we get a lot of concurrences and a lot of dissents in the emergency docket, but they're not particularly helpful for like a practicing lawyer, for the parties in the case, or even for the public, because you know what one justice thinks is the likely outcome on the merits, but like there is I think in one of the many cases right now in the emergency docket captioned Nome, it was out in California, and it was about the Fourth Amendment, but it was also about standing, and Justice Kavanaugh wrote a long concurrence saying, there's a little bit, I think they're going to win on standing. There's a little bit, I think they're going to win on the Fourth Amendment, but okay. And that's not really helpful because you don't know what his colleagues think about the standing. You don't know what his colleagues think about the Fourth Amendment. All you know is what Justice Kavanaugh thinks. And I have no particular reason to think that his views are reflective of the views of, his 8 colleagues. That's just him. So I would just say, I think we see a lot of separate writing on the emergency docket. It's pretty common, and that's because everybody knows you're not speaking for the court, you're just speaking for yourself. But that very fact that you're just speaking for yourself and not speaking for the court is why there's limited utility from a perspective of public explanation, or even for advocates or parties, or lower courts. It's just not, it doesn't tell you that much because, again, even in a normal case, what one justice says in a concurrence, what one justice says in a dissent isn't particularly useful to lower courts unless it sort of like supports something that the lower courts just wanted to find some citation for anyway. Does that kind of answer your question, or do you have a follow-up?
A little bit, but I'm just thinking if you're talking about this as solving the issue that a lot of people have criticized about there not being a reasoning or an opinion.
Yeah.
I guess why would judges want to adopt this instead of separately writing, explaining their own opinions as to...
Yeah, I think it's because...
Tyler, you get 30-second response.
Yes,
Okay.
I'll try to read one sentence. An unpublished opinion that's captioned per curiam or something like that would be, you're speaking for the court, you're speaking for a majority of the justices, and that's very valuable data for the world, for the parties, for the lower courts. I think that's my answer, if that makes sense.
Okay, everyone, please join me in thanking